This is Attorney Andy Marcantel and Attorney Marc J. Victor. We're the partners at the Attorneys for Freedom law firm, coming to you live for our live stream today. How you doing today, Mark?
Dude, what an improvement in the music before the live stream.
It was hilarious. Like, as that was playing, you and I had our headphones on.
We're totally jamming out. Yeah, going crazy. It was awesome.
Yeah, I think that this goes to show that we're dedicated to improving every aspect of our program. We got flamed in the comments last time. Appropriately. We deserved every negative comment. I think they said it sounded like dentist's office hold music.
It was terrible.
Let us know what you think about it. We chose something heavy. We chose a nice playlist of nice rock songs, and we're going to continue that. But Mark, there's something I'm noticing that you're wearing there. What is that,
dude,
by chance?
This is, let me see if I can turn it here. Don't be in doubt when you pull it out.
Hell yeah.
Look at that right there. Bam.
And I got my, we have them in long sleeve too, and we have some awesome new merchandise, and that's one of our big announcements today. You guys asked, and we answered, and we have a new merchandise store on the Attorneys on Retainer website. In fact, I heard very shortly before this broadcast that the marketing team has prepared a video. I haven't seen this video,
neither have I, no.
So we'll watch it live here with the viewers. Go ahead, guys, roll it. All right, well,
maybe not.
There it goes.
Super Embroidery out here in Phoenix. We're here checking out our new Attorneys on Retainer shirts. Let's go see how they're made.
Hey, that was a pretty cool piece of production right there.
Amazing.
You guys are amazing.
Yeah, awesome job.
Doesn't that just make you want to buy 20 of them?
Love it.
No,
love
that's
it.
awesome.
And they really are comfortable.
They're like super soft.
Yeah,
Yeah,
they really
super
are
soft,
comfortable.
Good quality.
Wear it with pride.
Yeah.
I mean, I'm pumped up to wear it. I'm proud to wear it. I feel great about wearing it because I know the job that we do for people. So, yeah, fantastic. People asked for merch. Now you got merch. We need to get these in the store.
these are badass,
yeah,
man.
We should talk about these.
Check
right
this out.
here.
Look, I'm gonna hold it up.
I think that's a 223 round. It looks a little bit bigger on the screen there. This came from one of our employees. He just came in, dropped it on the desk, and it's a pen made out of looks like a couple of 223 rounds.
If we just put the logo right there,
I think we got to get that too.
That's
That's
totally
pretty,
badass.
Pretty sick.
and we'll add some other things too. People want hats, and I've heard talk about tote bags because I hear USCCA gives a tote bag, so maybe we can.
I don't know, man.
But anyway, check out our merch store. We'll drop the link in the description. I think we just plugged it in that video. And yeah, we got some cool stuff there.
Yeah, and by the way, all the proceeds from everything that we sell in the merch store is going to the Live and Let Live Global Peace Movement. We haven't really blasted that out, so people might not know exactly what this is about.
People have asked for these mugs in there, too.
Yeah, I know. I've seen some requests for those as well. People can check it out. You can go to liveandletlive.org. You know, if you're cranky about the state of the world and you're tired of everybody just yelling at each other and you want something that's really hardcore pro-freedom on every issue, all issues. This thing's a global movement. There are people around the world. We started this at our firm, and it's moving really nicely. It's getting close to being launched. The only thing really we're waiting on is for me to finish my book, because we need to really lay out, okay, the phrase live and let live sounds great, but how do you get a whole criminal justice system, civil justice system out of that? Could it work? How does it apply to a whole parade of issues? That's what my book is going to address.
Yeah, the Attorneys for Freedom, we remind people of this all the time. It's not just a slick name.
Yeah.
It's a principle that we stand for.
That's right.
It's exactly what principles we bring into the courtroom. It's the principles of high character that we use with our clients, and it's the promotion of a free society that beats in our hearts. It really is. It is a firm with a mission, for sure.
Someone suggested we do a video about how you came to work at the Attorneys for Freedom. I think it's
actually a pretty good story.
It's a great story. But yeah, I mean, people who are attracted to a pro-freedom law firm where people are activists and we're not just about making money, we're about fighting for freedom, a lot of people have been attracted to that. And we've got a huge group of people at our firm who are really hardcore pro-freedom. I know there's going to be Armed and Fabulous coming up with Lauren Liberty. It's a new show we're going to be kicking off from one of our paralegals, Lauren, who actually went to Washington, D.C. and gave a big speech about Second Amendment rights, pro-gun rights, and the thing hit like 1 million views on the first release of the video. So lots of stuff coming. We are trying to do what we can to push the world in a pro-freedom direction.
We are walking the walk at this law firm.
No compromise.
Every single day and for every single client and for every single way.
No compromise.
That we can affect the world in a positive way and make it more pro-freedom. All right, guys, you've asked for a Q&A style format. People like the Q&A.
Love it. Love it.
And so make sure to leave your questions in the comments section, and our staff will grab those. But I think we got a few queued up to kick us off from the previous video announcements that we did. So why don't you guys blast one up on the screen there for us?
Yeah, let's get right to them.
We'll hop right in. All right, we've got DRBKJV9495 asks, after an incident, if the police want to just ask some questions, but you are not charged with a crime, can a member call AOR for their right to representation? Good question.
Yeah, this is a good question. I think some people were confused about this at the beginning. Look, an incident happens, right? You're not charged with a crime right there. It could be quite a while before you're actually charged with a crime. And so we always intended to represent people at that moment, but our fee agreement didn't initially say that. Now it says you're charged with a crime or you're reasonably concerned about being charged with a crime.
That's right.
That's good enough. Said another way, if you're thinking you need to talk to us and you're an AOR member, call us by all means.
Err on the side of calling us,
Absolutely.
right? Because many of these cases don't start with charges. They start with an investigation.
That's right.
Even if there's a body on the floor, oftentimes police will say, okay, well, we have questions. This might be self-defense. It might not. Maybe they need to consult a prosecutor. Maybe they just simply need to go talk to their superiors or their chief on what they want to do with it. There's usually an investigation. Sometimes there's testing involved. Sometimes there's photographing of the scene that needs to be conducted and processed. Sometimes there's forensics. Oftentimes these days in these investigations, for example, while they won't make an arrest or a charge in that moment after a shoot, they might seize a cell phone or a computer or a laptop and send it off to the crime lab, which in many jurisdictions can take months to come back from that forensic breakdown, just kind of depending on how congested they are. And they may not want to make a charging decision until they see the results of a forensic exam. So bottom line is, if you've been involved in a self-defense incident after you signed up in the program, even if you're not charged yet, err on the side of calling us.
Yeah, you said it best at the beginning. When in doubt, call us.
That's right. All right, next question. All right, Nicholas Roberts 9618. I'm a new member because of HDC. All right, shout out to HD. Would you commit to educating the public through your videos about their duty and natural inalienable right to use jury nullification? I love this question.
Yeah, just so happens I recorded a long video about jury nullification. It wasn't one that I had any time to prep. They came in and said, hey, Mark, we need a video about jury nullification. This has been a pet issue of mine.
Well, you and I actually recently got to talk about jury nullification in that taco shop shooting video.
Oh,
that
yeah,
we did.
very briefly.
Yeah, we did an analysis of the taco shop shooting.
We talked about that.
Yeah, in Texas, and jury nullification came up.
Yeah, so that prompted the team to say, hey, Mark, can you do a video about jury nullification? I said, okay. So we walked in. I just started blabbing about it, and I think it went kind of long like most of our videos. But I had a lot to say about it. I'm a huge fan of jury nullification. So were the founding fathers of our nation. The jury's supposed to be the final check against a tyrannical government. We need to bring back, we have jury nullification. We just can't tell the jury about their right to nullify. They have the power.
Think about that. Yeah, think about that for a
disgusting.
second. We as attorneys in trial are not allowed to inform the jury of their right that everybody agrees exists. Everybody agrees exists. We can't inform them of that, or it's an immediate mistrial. It's one of the many things that we've talked about on this show that kind of, if we could change certain things about the justice system, jury nullification would be high on the list. Like another thing, for example, another thing along those lines we're not even allowed to tell the jury about is, what are the punishments for the crime that you're considering finding the guilt or innocence of this person. We're not even allowed to make a peep about that.
Yeah, and jurors are required to take an oath to follow the law as given to them by the judge. Like, it would be great to stand there in front of the jury and say, look, ladies and gentlemen, even if you think the prosecutor proved every element of the crime beyond a reasonable doubt, you can still say, I'm coming back not guilty.
Yeah.
And the reason you should is because the law doesn't quite fit in this situation. That's why we talked about it in the taco shop case. Because in that case, when you look at it, it kind of, I mean, I think everybody agrees that last
The
shot.
ninth shot. Yeah,
After he grabs the firearm and then the guy's on the ground, he hasn't moved, he blasts another round into him. Okay, that's probably not justified. In fact, I think I can say with confidence that one wasn't justified under any theory. But still, it's pretty clear who the good guy is and who the bad guy is. And the jury, if that one was charged and went to trial, you want to be able to say to the jury, look, even if you think he blew it here, you can still come back with a not guilty. So there's a video coming on that. I love jury nullification. Wish we could talk a lot more about it. It'd be fun to get a debate if we can find some prosecutors who think that jury nullification is a bad thing. It'd be fun to have some debates. In fact, we should cut a whole video on things that we think are wrong with the justice system and how to improve it. That'd be a fun one. I've given speeches on this before.
Yeah, and there's a lot we can say about that. And I tell people all the time who come into my office and ask me about questions. Oftentimes I have to tell them about statutes that I personally disagree with. And I say, remember, because I'm telling you this is what the law says, don't take that to mean that I agree with the law or that I think the law is right or I think the law is moral. But this is one of those areas that we as their advocates aren't allowed to even make a peep about. But yeah, very good point that we should make a video about how we would tweak the justice system in little ways like this.
We should get that on the list.
Yeah,
all right,
absolutely.
let's get the next one.
All right, James Knight, 5355, asks, what is the definition of intoxicated as it relates to CCW permits? Are sensitive locations laws enforceable throughout the U.S., given the 1791 2A historical text? Let's take those in turn. So first, what is the definition of intoxicated when it comes to CCW permits? Well, it depends on the jurisdiction is the short answer there. Every jurisdiction is going to have different definitions of what it means to be intoxicated for the purposes of different crimes and for the purposes of different regulatory things like a CCW. But that's the technical answer. There's probably a more pragmatic answer as your criminal defense attorneys we'd recommend. Would you agree with that, Mark?
Yeah, it's called don't drink alcohol if you're carrying your firearm. Not a good idea. Look, if you're in an emergency situation, maybe you have been drinking, you're home, you're drinking, you're out somewhere else, you're drinking, someone breaks into your house, okay, you're going to have to grab your gun to defend yourself. Fortunately, you're not with one of these other programs that says, oh, sorry, you're intoxicated, no coverage for you. You guys are with AOR, so we don't care about that stuff. But if you can avoid it, you should avoid it because obviously it's going to be something that the other side is going to point out to and not like. But the issue isn't really in a self-defense case, were you intoxicated? The issue is, did you act reasonably?
Right.
Did you subjectively act in a way you thought was in self-defense? And is it objectively reasonable? And as everybody knows, that's a question for the jury to answer.
When the prosecutor gets to say, and the defendant was intoxicated, they love being able to say that when they're trying to convict your client. And it's one more thing that they can put on that scales of reasonableness against you, right?
Yeah, and to be fair about it, it's probably something I'd file a motion in limine on and try to exclude and say, Judge, what difference does it matter if he had alcohol in the system? That's not the question. The question was, did he act reasonably? So it's irrelevant and it could prejudice the jury. You might convince a judge to keep that out.
Yeah, that's absolutely fair. There was a question about are sensitive places allowed, and the answer is from the Supreme Court. I think a statute was cited there, but from the Supreme Court, from the top.
You're talking about the Bruin case.
In Bruin, they said, absolutely. We've long recognized sensitive places is okay. The issue is that these kind of gun-grabby jurisdictions, in response to Bruin, are expanding the definition of what a sensitive place is. If you guys have seen my I did a short analysis, quick and dirty breakdown of SB2 in California, and that kind of will give you a flavor of not only what's going on in California, but those types of jurisdictions around the country.
And, the Supreme Court kind of put their foot in their mouth on this, right? Because this stuff started in the Heller case. In Heller, they were employing a different analysis than they were using in Bruin. And so in Heller, they said certain things are still going to be constitutional. Then they changed the test in Bruin, which is now the historical test. And so I think if, somebody made a challenge, and I'm sure they're out there and they're coming, which is, look, sensitive areas, there's no historical precedent to ban firearms even in sensitive areas.
Right.
So I don't know how they're going to square this one, right? The same with the prohibited possessor issue, and that one's coming soon in front of the Supreme Court. So we'll see how they're going to square this stuff. I've also done a video. I think if people Google Mark Victor in the Range case, Range, they'll see my analysis on that in terms of, and as usual, I went a little further and gave more information about how things have developed with the Supreme Court and some history. And
Yeah, there's some really interesting prohibited possessor cases going up and
There's
up
good
and up the
stuff
chain
coming.
right now. Yeah.
I think they.
And the idea here is that, of course, there ain't no long-standing historical background of
Either.
depriving somebody of their firearms rights for crime X, for example,
That's
for a
right.
nonviolent offense or something.
We
like
have the
that.
one coming with the restraining orders, the
Right.
domestic Rahimi, I think is the name of the case. And so we're going to give a full breakdown, obviously, when this case gets out there. But I don't know what the Supreme Court's going to do because the test they put out there doesn't allow hardly any restrictions on firearms. So it's going to be interesting to see because they're the ones who said prohibited, people who have committed felonies in sensitive places. They got to square that with their test, and I don't know how they're going to do that.
It's going to be
So-
very interesting.
Yeah,
We're
it's
going to
gonna-
see some contorting going
Yeah, but
on.
this is the most pro 2A court we've ever had in the
More
history.
likely to contort in favor of the Second
Yeah,
Amendment.
yeah. So
That's
I
the
think
thing.
we got a pretty solid Supreme Court for people who are pro gun rights.
That's one of our favorite things to do, by the way, is look at Supreme Court law and analyze it and go through an opinion line by
Yep,
line.
love
If
it.
you guys want to go check out our analysis of Bruin, we did our own little history of the
Yep.
Second Amendment jurisprudence and
Yeah.
went through all of these important cases. So go check it out. All right. Anthony Delman, PhD. What's up, doctor? 7311. Are there any recommendations of things we can do as gun owners to best protect ourselves in the event we are involved in a self-defense scenario? Big question right
Ooh,
there.
Well, I can tell you what I don't recommend. There was an attorney out there. We did a short on it. Who's, this guy.
I know
He said, "I know, I got a
exactly.
great idea. Blow a few rounds into the ceiling, and then you can say, I first fired a warning shot." Okay, and I said, "Don't do that." I was actually horrified by that advice. So
Yeah, I'm surprised. I don't know if the bar has come a knocking yet for him releasing that video advising all of YouTube to tamper with evidence and, falsify evidence at the scene, but you shouldn't do that.
Yeah, so the question is really broad, right? Because it depends on the facts. I mean, it's so hard to give general advice. And in fact, there's another video that I recorded that's going to be coming out soon that went into great depth in terms of, Mark, I got more questions on what to say. Just shut up. Okay, that's great, but there could be more things. There could be times when I need to say something. So I cut a very detailed video on that's going to be coming out soon. But as it is a very, very general piece of advice, keep your mouth shut, right? Because even if you think that you are in the right, there's a million reasons why you can have problems here. And so we don't need to recount them all here. But I think in terms of things that you can do after a shoot, keep your mouth shut. We always like to say, if human life is in danger, then either you or preferably someone else has got to call 911. We don't want a lot of information. We're thinking something along the lines of, "Hello, 911. We need medical attention immediately." If you think you need to say there's been a shooting, don't say I shot someone or anything like that.
In fact, best if you could have a third
Yes,
party call if
there's
if
been a
one's available.
shooting.
Yeah.
Please send help immediately. Here's the address. Goodbye. Click. Because that 911 operator is going to start asking a million questions. If human life is not in danger, right, then you call us first.
That's
and then
right.
we'll decide what to do from there based on
In
the
fact,
facts.
Mark, we recently had one where human life wasn't in danger, and our advice to our AOR client was actually, we're not recommending you call the police or anybody for that matter, and it became a big nothing, right?
That's right.
Whereas had this person called the police, probably would have been charged with a felony in our estimation.
How many times have we seen somebody call the police to say, "Oops, I had an accidental discharge," or something happened, which would have gone nowhere, but instead turned out to be a felony charge against the person who actually called the
That's
police?
right.
So call us, let us make that judgment.
Something super important that I really want to emphasize here, because the question was, how do I protect myself? And I'm sure it meant legally, but let's talk about protecting yourself from being killed by the police who show up on scene.
There's a good one, yeah.
So important. Do not appear to be a threat in any way, shape, or form. Wherever the gun is, make sure it ain't in your hand.
Yeah,
Make
'cause-
sure it's not on your person.
Yeah, think about it from the officer's perspective, right? They get a call, there's been a shooting, and it's at this address,
Send
and that's
help.
all we know.
Yep.
So they're coming in, they're not getting shot is their attitude. They're coming in, they don't know who the good guy is, who the bad guy is. So you want to make it very clear. The last thing you want to do is have a firearm in your hand
Right.
when those police arrive.
Yeah. All right. Let's move on. All right. I'm not sure who it's from. It might be one of those previous questions. Does AOR cover misdemeanors and are members automatically grandfathered in? Oh, this was a call-in question.
Oh, okay.
My staff's telling me. Okay, somebody called in with this question. Yes and yes.
Yeah, that's an easy one. I understand why people are confused because at one point we didn't cover misdemeanors. And so, there may be some videos out there floating around. In fact, I got a question recently. Hey, Mark, I love AOR, but I see it's only available in Arizona and Hawaii. When is it going to be national? All right, so there's some old videos floating around out there I think we need to clean up. But yes, we've changed the program. Yes, you're grandfathered in. Don't worry about it. If your
rate doesn't change, your coverage doesn't change, everything as we upgrade and that applies, by the way, to everything that we're going to do. We're going to keep a static price, and we're going to increase the benefits, and we're not going to charge a dime more for every single improvement that we make.
That's the plan.
Proudly. All right, Wind Warrior Protection asks, does the client need to put up collateral for bail? If an attorney cannot pay bail or lend the defendant money, how does AOR manage to cover bail given that restriction? Great question.
Yeah, two good questions. Let's deal with them one at a time.
Yep.
Does the client need to put up collateral for bail? Well, it depends, right? If the amount of the bail is $50,000 or under, and it's a cash bail, a cash bond, sometimes judges say cash only. And if that's the case, then AOR will handle that, no problem, because we cover up to $50,000. If it's over $50,000, then we'll put 10% down, and then the bondsman comes into play. The way that works is that 10% goes to the bondsman. That's the bondsman's fee. The bondsman then puts up the bond, which is essentially a piece of paper that says, hey, if this guy flees, I promise to pay the $100,000. The bondsman's not going to do that just out of the kindness of his heart. He's going to put it up, but he's going to say, look, if I got to pay the $100,000, I want to make sure my ass is covered and I get reimbursed. So they're going to want collateral, which in this case, could be a house. Although sometimes a bondsman will take cars, they've taken jewelry, guns, whatever, if they're comfortable with the amount of the collateral they have. So AOR does not supply the collateral. None of these other companies do either. You got to supply the collateral. We'll supply the money. But if you've got the collateral and we got enough money here under $50,000, we'll get you out immediately.
Let me say one thing about that before we go on to the second part of the question. Make sure to go and fill out your information sheet online in your client portal, because what you can do is kind of share with us some of the assets that you have. So in other words, what kind of collateral you can put down so that we know when we're either negotiating with the prosecutor on release conditions or maybe even doing an oral argument at an IA or a motion to modify release conditions in front of a judge, we kind of know what the target is that we're trying to hit. And that this is just a practical thing that you can improve your situation on ahead of time and being proactive.
I think we did a video on this too. Some people have said this is too much information. I don't want to fill it out. Our position on that is, okay, fine, you don't want to fill it out. But the reason we're asking you this is because we know what needs to be argued at your release hearing.
Did people say that's too much information? I don't want to.
Yes, several people.
That seems
ridiculous
wild to me, because why would you pay for a self-defense program and not take
part of the
time
reason
to improve your position?
Part of the reason you went with a law firm instead of an insurance company, because we know what needs to be argued at that first hearing. So we want that information at our fingertips, just in case the way it comes down is we can't talk to you. Maybe you're arrested, thrown in jail, and it's hard for us to talk to you. We got everything we need right here. And other people have also worried about the fact that, this is going to be used for marketing purposes or something. Look, we're a law firm. We are under very, very strict rules to keep everything confidential. What you provide to us is covered by attorney-client privilege, which means it can't be discovered. There's just no downside to giving that information. But if you don't want to...
It's on a completely protected server. It is attorney-client privilege. There's a 0% chance that it's getting out there. As soon as you type it onto the page, since you're associating with a law firm, it is non-discoverable and we can't disclose it for any reason.
Okay, so second part of the question. We also did a video on this that I think is going to be coming out soon too. But so there are a minority of states that have some ethics rules that say a lawyer cannot post bond for a client. So the question is, how can we do that? All right, well, so we're prepared for this. The way we sort of deal with this situation is we don't. We have a third party who has made a very generous donation into a fund that is specifically to be used for this purpose.
That's right.
The funds are irrevocable, which means the person can't take them back, and we have access. We have the power of attorney to access those funds. So in such a case, what we do is we say, oh, we're in one of those states. Like, for example, Wisconsin is one of those states. If you are in Wisconsin and you're an AOR member and you get arrested and a bond is set and we would otherwise post it from our funds, we say, that's one of the states we can't do it. We dip into the third party fund and on behalf of the third party, use their money to post it up in Wisconsin.
Yeah, this is a really good solution to this potential issue, right? When we're setting up this program and trying to figure out how to service the whole United States with our program, we spoke to a lot of really, really smart, qualified people on these issues, not the least of which is our wonderful ethics council. We love our ethics council. We want to make sure that everything we're doing totally is above board, passes every possible conceivable challenge ethically. And then we started talking to insurance lawyers to make sure that our product didn't stray into an area that we are not interested in being, which is these insurance, qualified as insurance. And so this is an interesting way that with some states, because remember, different states have different rules, this is an interesting way that in some states we can remain compliant with those state requirements and jurisdictions while not violating any
So
rules.
we have a wealthy donor who's very pro Second Amendment, who understands the situation, says, if you guys think that this person's got an argument for self-defense, I'm happy to put it up on behalf. I'm a big fan of attorneys on retainer. I'm going to keep this program going, use my money to make it happen. So no problem. That's how we get around that situation.
Awesome. All right, let's get another one up there. John Latz, have you had any experience yet working with any of the other insurance plan-based groups? I was wondering about having both AOR and another plan in place.
Let's start with the second part of this one. First of all, we have no problem working with any other plan. I've worked with many attorneys. In fact, every time you do a death penalty case, you have to have two lawyers on the case. They can't be from the same firm, so you have to have two separate lawyers. And I've worked with many lawyers, never had a problem. And so if you have one of these other companies and they provide a lawyer, happy to work with that person. Our attitude is we got a mission to accomplish, and if we've got another qualified lawyer on deck who can help beat up that case, let's work together and make it happen. It's all about the client. And that's, if it's a real lawyer, they're not going to care about what program or any of that. They're going to fight for the client. That's what real lawyers do.
Yeah, when we're representing an AOR client, our number one priority is we want to put together the dream team for that case, whatever it looks like. And sometimes it makes sense to have multiple lawyers with different specialities, who can specialize in different parts of that case. Same with the experts, same with the investigators. We're looking to put together a dream team. Sometimes our clients are just more comfortable with an attorney that they already have an established relationship with. And so while we might find kind of a heavy hitter in the 2A world, they might also want to get involved, a friendly attorney that they just feel comfortable having involved. We say, no problem, we'll pay for it all. We want the client to feel comfortable. We'll make the dream.
Yeah, we're not confused about why people have signed up for attorneys on retainer. They want a kick-ass defense, and that's what we intend to bring. We're not going to skimp on that because that screws up the whole project. That's not what we're about. It's not what Attorneys for Freedom is about. It's not what Attorneys on Retainer is about. So the other part of the question was interesting, too, because you have personally had some experience with. Why don't
Not
you
a good one.
Tell a little bit about that story.
One of our competitors, this is before
AOR.
This was before AOR was launched.
Before AOR National,
the national plan before we had the self-defense program. I was contacted by one of our competitors. I won't name them. But they had one of their members who had the highest level membership of what it is. I won't say what it is because that might reveal the program. But they...
by the way, we could have bashed them right here.
I could have totally bashed them.
We could have said the name of the... There's nothing preventing us from saying the name of the program. We could have done that, but we're not doing that.
And they try to keep it classy. And
Right.
hopefully... Okay, well, at any rate, they were involved in a shooting. And I got a call first from the program, and they said, "Will you meet with our insured?" I said, "I'd love to." I sat down with that person for a long time. It
That
was
person selected our law firm
That's correct.
as their chosen lawyer in their program, and so the company reached out to us
They
first.
they researched us and they said, "I want these guys." And the insured informed his company, "I want these guys." They called me. They said, "Hey, give them some time, have them come into your office." I sat down with them for a long time. We went through everything in detail. And how I left that meeting was with the opinion, this is a solid self-defense case under Arizona law. I would love to take this case. And so I called up the company. I let them know I'm very interested. I think your insured has an excellent self-defense case. And the whole time I was on the phone with this person from this company, I felt like all they were trying to do, rather than listening to my arguments about why it was a good case, I said, "Yeah, but isn't that a problem that they did this?" "Well, no, not really. I mean, in the grand scheme of things." "Well, isn't it a problem that they did this and blah, blah?" "Well, listen, no case is perfect. You're never going to have a perfect set of facts. Sometimes there's good, sometimes there's bad. What I'm telling you, person, is the good vastly outweighs the bad. Under Arizona law, we've got an excellent argument for self-defense." Okay, I'll get back to you."
I remember you coming into my office and Mark, great case. This company's going to fully fund it. We can go in and kick ass. We're pumped up about defending this guy.
A week later, I get a call saying, "We have disclaimed liability for this claim, and we will not be providing anything for his coverage." So that's how it ended. And I called them to ask why, and I didn't. I left voicemails. I never got a call back. So
Yeah,
that was my experience working with the other company.
I thought we had a similar one with a different company. Maybe I'm forgetting. I don't remember over the years. But anyways, we've had some bad experiences with some of these other companies, which is part of the reason that we felt like, you know what, there's a real niche in the market here for us to do attorneys on retainer.
You had an interesting experience with one of these prepaid legal programs where they told you to just discount your normal hourly rate, but didn't tell you what it should have been.
Yeah, this was one of those programs where the person in the program got a 20% discount off of our rates. And I said, well, at this time we were charging flat fees. And I said, well, we charge a flat fee. What's the rate that I can charge? They said, well, we don't care what you charge. Pick any rate you want and show 20% off the thing. And then that's what we'll pay. That's what the person's going to have to pay you. That's what their discount is. And I thought, you know what? This thing's just total BS. In fact, this happened even before we started AOR at all. This is what got me thinking, wow, these programs are kind of garbage. They're garbage. They're fraud, actually. At least this one was. And I thought we could do something a lot better than this. And that's what got the wheels turning for attorneys on retainer.
And we have. All right, next question. Manu Oberoi, how does a person's spouse avoid getting arrested in a self-defense incident if they didn't pull the trigger? What should they say without at the same time being self-incriminating? So how does a person's spouse avoid getting arrested in a self-defense incident? I'm not exactly sure.
I think the question is the spouse, as I understand, the spouse isn't involved in the self-defense shoot. Police come out. What she wants to say is, I had nothing to do with it or something like that, and avoid getting arrested. I think the short answer here is just shut up.
Yeah.
Right? I mean,
maybe the question was saying that if the spouse called the police for the defendant or for the suspect.
I read the question as spouse wasn't involved. Police are going to arrest spouse because they don't really know what happened.
Right. Oh,
and spouse could say, hey, it wasn't me. I wasn't involved in anything. But instead of spouse remains silent, spouse is going to get arrested. Look, don't confuse the desire to not be arrested with stuff that could actually help the case, right? The big issue is the case, not the initial arrest. I know nobody wants to be arrested, but imagine spouse keeps mouth shut and doesn't say anything, and maybe it's clear somebody pulled the trigger, but they can't prove who.
If they can't prove beyond a reasonable doubt who pulled the trigger, you're going to be in good shape.
And spouse says, well, I didn't pull the trigger, now
There's one suspect now.
Yeah, now there's one person involved. So I don't know. I mean, that's one of many
People don't want to be arrested, obviously, if there's a way to prevent it. But you got to keep in mind that the short-term goal, which is going to be unpleasant, no doubt. If you get arrested and taken to the station, it could screw up what you got going on in your world at that point. It's going to be extremely unpleasant. Getting convicted and understanding that the reason why that conviction happened is because you couldn't help but open your mouth at the scene and you blew up your case for whatever reason. Even if what you're saying is true, it can be twisted. They will read in subtext the things that you didn't say.
I
We
know.
oftentimes say this all the time, that you're stressed in that moment. You may, if you choose to waive your Fifth Amendment rights and speak to the cops, oftentimes you leave things out. It's one of the worst possible times in states of mind you could be in to speak to the cops. So if you realize now, oh, okay, I've screwed up my defense because I chose to talk to the cops, you'll wish that you had agreed to be arrested that night in order to get that argument back.
You know, in that debate that I did with Masad Ayub, and he was trying to make the case that, well, you should say some things to the police officer at the scene. That was his big argument, that, you might be able to avoid the arrest. And of course, he assumed, and eventually I got him to admit in that debate, he assumes it's a good shoot. He says his advice is only good if it's a good shoot. If it's a bad shoot, well, heck, you're on your own, not worried about that. I train people to be involved in good shoots, which I think is flawed, right? And I mentioned that in the debate. But I still think avoiding the arrest, like you say, might be a good short-term goal. But if you screw yourself on the case, or in this case, maybe your spouse, right? Because you said something, imagine you avoided getting arrested, but you made the case much worse for your spouse. I don't think that's going to be very good for the marriage overall. So
Yeah.
I think, again, keep your mouth shut, or another option, call us right away, because there have been many occasions at the scene where I've been able to, I get the story from what's going on, and I'm able to talk to the police. Hey, can you put the police officer on the phone? They don't have to get on, but in many cases they do. And I get to talk to them. There might be some advantage for the lawyer to just communicate, say, here's how I understand the facts. There's this, or the things that Masad is worried about. Make sure you check to preserve this piece of evidence or that piece of evidence, or I know there's 2 or 3 witnesses. You might want to interview them. Most police officers are going to do that anyway, but there could be some benefits to saying some things to the cop, but get it through the attorney.
Let your lawyer be
Right.
let your lawyer do the talking here so that these statements can't be attributed to you. So here we are again saying just shut
Call
up
us.
and why important it is.
That's what we do.
Yeah. All right, next question. Alex I'm going to screw this up. Sierra, with SB2, does the Fifth Amendment trump the duty to inform? Am I allowed to remain silent under the law? Could a prosecutor go after failing to inform an officer of the weapon? And this is an interesting question, and there's a law in the state where our law firm is located here in Arizona that actually makes it a crime to not answer truthfully when an officer pulls you over, you're in your car, and they ask you, do you have a firearm in the car? It's actually a crime to refuse to answer truthfully,
Yeah, or
which,
to lie, yeah.
which we frankly believe is a blatant violation of the Fifth Amendment, and we're looking for a good case. So if you know anybody who's having problems with any such crimes around the country, refer them to us, because we're looking for a good challenge.
Yeah, I've been looking to challenge the statute for a long time, but the problem with it is you only have a right to remain silent if you're in legal jeopardy, right? So what we're actually looking for in a case like this, and I think with this question too, is somebody maybe who's a prohibited possessor, who has a firearm or is in some way breaking the law.
Like an illegal firearm or
Yeah,
something like that.
or maybe is in a sensitive area or something, and the police officer is asking a question, do you have a firearm? Okay, now you're in Fifth Amendment jeopardy, because if you answer that question, that answer can be used to incriminate you. And that's the situation. It's not just, hey, I'm not breaking the law and I just want to remain silent. I think people misunderstand the Fifth Amendment. You have to be in legal jeopardy. Otherwise, you can't assert the Fifth. People try sometimes to assert the Fifth on the stand. They say, I assert my right to remain silent. And then a prosecutor will say, this guy's not in jeopardy. And the way they get around that, they say, we'll offer you immunity. And now you're not in jeopardy, so now you have to answer. So these are the kind of legal battles we get into sometimes in a criminal trial. But I think that these do raise questions of constitutionality. We just got to get the right case to challenge it.
Yeah, there's this interesting constitutional concept that we've definitely brought in a number of our cases. It's oftentimes called the cruel trifecta, okay? And what this means is, and this is what the Fifth Amendment is really geared towards preventing, is that we don't want to put a suspect in a place where if they answer the question, they're screwed. If they don't answer the question, they're screwed. Or if they lie, say they're screwed. And right, you can imagine in these scenarios, okay, say that you have a firearm in your possession in a sensitive place. Well, if you answer correctly, you're screwed. You've just admitted to knowingly possessing in a sensitive place. If you don't answer correctly because there's a law like the one that we just described, you're screwed. You get charged with a crime. And if you just refuse to answer and invoke your Fifth Amendment to remain silent, they're going to transport you now over to the police station with a gun. And so now they're forcing you to basically commit the crime of bringing contraband into a facility, for example.
Which is
so
a really
you're
serious
screwed.
one, yeah.
And the whole idea of the Fifth Amendment is we don't want to put our citizens in a position where whatever they do, they're screwed.
Yep. And then also, just as a little footnote, people forget, and I think some lawyers forget sometimes, there's often a state constitution that has a provision that is very similar that can be more broad. Arizona has one that's drafted more broad, not just that statements can't be used against you, but evidence can't be used against you now. The Supreme Court hasn't interpreted it the way I think it should be interpreted, but it's in there. So it's always important to look at the state constitution as well as the federal constitution.
Yeah, I think I should mention, too, I think I misstated. I said cruel trifecta. It's cruel trilemma, like a dilemma, but a trilemma. Just want to make sure I got my constitutional law right.
Trifecta for the prosecutor, baby. I don't know.
Next question. All right, from Rock, Texas, baby. Question, generally, after an incident has occurred, are you required by law to relinquish your firearm used in the incident? Good question.
Yeah, I mean, normally when a judge releases somebody, and this is another one of those areas that I think is going to be challenged under Bruin, and I think there already have been some cases that have said, look, we don't have anything in our nation's historical tradition that says just because you're released pending a felony, you're stripped of your Second Amendment right to keep and bear arms. So this one's coming down the pipe too. But at the moment, very, very, very common, I think in almost all cases, if you're released, especially on a felony case, the judge is going to say a condition of your release is to give up your firearms.
Yeah, I think, and maybe I'm going a little bit premature in what that question's trying to get at, but at the scene itself, like basically the shooting has occurred, and I could be wrong, I could be misinterpreting that, but shooting happens, cops show up, do you have to relinquish your
they're going to
firearms?
say that's evidence.
Almost always,
Yes.
not because of a constitutional issue, but because it's evidence in the case. They need to go and test it. They need to have that evidence in custody. I've told clients before on the subject of obviously good shoots that if a cop allows you to keep your weapon after a shooting incident, it's a really good sign.
Good sign.
We've seen people get charged even despite that, but it's rare. It's usually a good sign if they hand it back.
Yeah, they can pretty much seize anything if they think it's evidence of a crime, right? Cars get seized all the time.
TVs, computers.
Yeah, anything they think there might be prints on or something like that. They can freeze the whole scene, right, and go in and say, we're going to process the scene. It's evidence in a criminal case. So
and that gets us into the ugly, ugly world of civil forfeiture, but we don't have to go down that road. That's a different video for a different day. All right, next up. Peter Foman, what are my rights regarding the police questioning my minor children without my consent or present? I love this question. Are there any recommendations or experiences you can share regarding this situation? All right, thanks, Peter. I love juvenile law cases, and I love what the Constitution and the courts have had to say about the rights of minors and the rights of parents. I think it's a really, really important area to study, and the rules are different for how the cops treat minors as they are with adults. In fact, most jurisdictions, if not all jurisdictions in the United States, even have a different version of Miranda warnings for juveniles than they would for adults. We call it juvenile Miranda. The idea being here, if you have a 14-year-old or a 15-year-old simply spouting off the Miranda rights, you have the right to remain silent, anything you can do. The idea is that a child's not going to understand what the heck you're talking about. And so there's different rules, different things that need to be read to them. But also courts have given very, very close looks to what constitutes coercion when you're dealing with a minor. And in Arizona, we have a factor-based test where the Supreme Court has taken a look at it and said, okay, let's say that the minor made a statement, an incriminating statement. And so the question is, was this a coerced statement? Well, we're going to look at several factors that we're going to kind of weigh back and forth. Was the minor free to leave? Were the minor's parents present? Were the minor's parents, did they give their consent? Were there police officers surrounding and intimidating the minor at the time? Lots of different things that they've laid out.
How big was the room the minor was in? How many officers were in there?
Was the officer displaying a gun at the time or displaying force?
Did the minor get a glass of water? There's all kinds of things, and really this is is only limited by the creativity of the defense lawyer.
Right, right. So the answer is yes, there are different rules that vary in different jurisdictions that say, no, no, we don't treat minors the same way. We have to respect certain parental rights in certain areas. And if they say something that's incriminating and it was gained through coercion and inappropriate means, then it comes in. The remedy is that it comes in and then your defense attorney complains about it with something called a motion to suppress and tries to get that statement out.
Yeah, I think it's important to preserve the arguments, right? So if this is happening, you want to say to the police officer, I want to be present during any statement. I also want the lawyer present during any statement. You know, and there are cases that sometimes reflect the number of times you've asked for that. So I always say ask for your lawyer early and often.
Yeah, teach your kids if the cops come and they want to talk to them, teach your kids to ask for their lawyer and their parents to be present and then shut their big mouths.
Yep.
If you can do that, then that's going to put them in a much better
Yep,
position.
totally agree.
All right. Gary Webb, what should an AOR member say to police right after a self-defense incident? Should I call an AOR attorney prior to police arriving on the scene? I think we addressed both of these pretty well.
And there is a video coming out on it.
Yeah, and so definitely the general rule there is if human life is not in imminent danger, call us first. Err on the side of calling us first because we may advise you not to call the police.
Yeah,
It
otherwise
depends on the situation.
as little as possible, and be very nice about it, right? There's no need, remember, police officers have a lot of discretion on the side of the road. This goes for traffic stops as well. A lot of discretion on the side of the road. There's no advantage whatsoever to being a jerk. Be kind, blame it on us. Oh, I got a good friend, Andy or Mark, and they told me not to ever say anything, and I'm happy to, if they tell me it's okay to talk, I'm happy to talk, but I'd like to call them right now. Would that be okay, officer?
Yeah, and then when you call us, we're going to say, hell no, they can't talk. And if we say anything other than hell no, it's not us on the other side
Right,
of the
or
line.
we're
But
being coerced.
yeah, I always tell my clients, kill them with kindness and blame it on me. I'm
Yep.
sorry, officer. My
Right.
attorney, Andy, told me I'm not allowed to answer any questions. Can I call him? I'd like to call him right now.
Yep.
I'd like to call him right now.
Right, good way to put it.
There you go, guys. All right, Freedom Cat. What do you think of having security cameras at home in the event of a self-defense shoot?
Could be the best thing or the worst thing.
That's right.
Depends on what the camera
Because
catches.
the cops are going to get it. If it's available, the cops, when they show up to that scene, are going to get that very, very relevant evidence, and you'll either be very happy or very upset that it exists.
Yeah, I mean, we've seen both cases, right? We've seen security cameras really be very helpful in terms of defending the case. We've also seen them be the worst thing ever, right? Clients sometimes will come in and say, this happened, then we get the camera on the thing, which is very different. Same thing with the police body cam. Sometimes they're great, and sometimes it's the worst evidence in the case.
Yeah, simply think of some of if you guys spend any time on YouTube watching different shoots and how they're analyzed and everything like that, if you just simply think about this question for a second, where you've seen a number of different YouTube videos that were maybe captured on a Ring camera or like people shooting through the door when people are trying to get in and it's deemed a bad shoot, that evidence wouldn't have existed, right? And probably the presumption, like when you have somebody shooting through a door when people are trying to get in, probably the presumption is going to be those were the bad guys, this is the good guy, the homeowner, and so the prosecutor will probably say, let's err on the side of not charging it. There have been a number of those Ring cameras that because they existed, the prosecutor said, that's disproportionate force right there. I'm bringing the charge based on his own camera. So this is a tough question.
Yeah, I mean, it really turns on whether what you did was defensible or not.
Yeah.
So it's hard to say.
All right, moving on. Bob Masavo, how do you keep the police from not shooting you when they show up? Good question. Don't have the firearm on you for
Yeah.
sure. And don't look like a threat, period. Maybe one of these
Yeah.
right here on your knees.
Right.
Be compliant. Don't have a scowl on your face. Don't move your arm. No sudden movements.
Right.
We've seen many innocent people in our job, unfortunately, get shot because they decided to make a quick movement or quickly go towards the cop. You guys, I'm sure, have seen videos like this online. There was a recent one that was very sad
I remember.
of the cop that shot the kid who ran down the stairs.
He was unarmed,
That's right.
Yep.
Very, very tense situation.
but he came
Somebody
out
just
really
comes,
too fast.
he comes running around, arms in the air, everything like that. And just sad case, but don't let that be you.
Yeah, I'd go overboard on making sure you don't appear to be a threat, right? If you got to be face down, keep your arms like that. In fact, if there's a firearm, you may, put it somewhere far away, secure the scene as best as you can, make it very clear you are not a threat. Whatever you got to do to make sure there's no misunderstandings at the scene, and there's still no guarantee.
Yeah, don't get shot by the cops. All right, Wild Alaskos at Attorneys on Retainer. Will your service cover armed private security if an incident happens while on duty? Yes.
Yep. A lot of these other programs say no. The one thing we do say about that in terms of on-duty incidents, if you've got coverage, and this would maybe be for a police officer or something, say you got FOP, Fraternal Order of Police coverage, and they're going to put a attorney out there. We're still going to get involved and help on the case, but we let them kind of drive because they're the primary on the case. If you have nothing else, then yeah, we'll get involved and do the case. So no problem. Again, we're not looking for reasons to deny people.
That's right.
We defend people.
We're going to want to get involved in the case. We're not going to want their attorneys to kind of shove us out. So we'll do everything we can to stay by our client's side the entire time, including things like getting experts, investigators, things like that, throwing resources at it to help make that dream.
We're going to make sure that that this person is our client, that they are going to have the best possible defense. Period.
Damn straight. All right, John LT 932. What do you say to 911 when you feel like you're forced to flee the scene of a self-defense shooting?
Forced to flee the scene.
Yeah, I don't know. This is tough. Maybe that there's more hostile people there, right? Maybe the bad guy had friends or something like that are still being an active threat, and so you feel like you need to leave the scene.
Yeah, I think it's important, if you're going to say something to 911 here, and that, again, can open a can of worms, it's important to make clear what we call your mens rea, what your mens rea is. This is the same situation. Imagine single female, alone at night, and lights come on, and you're not really sure if this is somebody impersonating a police officer, and there's nowhere to pull over safe right there, and then, a mile down the road, there's a store with lights or something. This is the time you get on to 911 and you say, hey, I'm being pulled over. I don't know if this is a real police officer or not. I'm intending to pull over. I'm going to drive up the road where it's well lit, and I'm going to pull over right there. I'm not a threat to anybody, something like that. So I'm making an analogy to that situation. If you find yourself on it, for some reason you need to flee the scene, again, if you call us, we can report this information. But if you find yourself on with a 911 call operator, look, I want to make it clear, I'm not leaving. I'm just trying to get away from a dangerous situation. Happy to, tell you where I'm at, that kind of thing later. Because we don't want to have, some kind of a consciousness of guilt instruction.
Right. That's the issue. Every time somebody flees from an incident, prosecutors are jumping on that saying, aha, consciousness of guilt. In other words, I want the judge to allow the state to introduce the fact that he left in order to try to get the jury to draw an inference that he knew he did the wrong thing.
Yeah, and with the right mens rea, now we say, look, my client was just trying to de-escalate the situation, not trying to flee, not trying to escape responsibility, but trying to say, hey, look, and here's the recording, I'm not trying to take off. I'm just de-escalating the situation. I'm getting out of there because there's dangerous people or whatever.
So, yeah, that's if you have to talk to 911. But still, better to come from an attorney. Like if you were to get us on the line, we might contact the police department directly. We might call 911 for you. We might direct a third party what to say that's in your best interest. So err on the side of calling us if you're involved in that kind of
I feel for people here, right? Because what they want to know is, what should I say?
Right.
And the problem is, it's so hard. In fact, it's impossible to give one thing to say that applies to every possible situation, right? I mean, I don't know what could be behind this question is, you had a valid self-defense, and now there's more people coming, and you want to just take off. And you do take off, okay, we got to do something to deal with that situation. You might have to say, hey, I just want to say I'm not fleeing the scene. I'm trying to retreat because people are chasing me or something like that. I don't know, but...
Well, you just illustrated something that our program has that people have told us they find extremely valuable, which is just the fact that they have a lawyer that they can talk to on the other side of that emergency hotline. You're not going to get that with an insurance company. You're not going to get that with one of these other competitors. You're going to get a lawyer quickly who can give you advice for your individualized situation.
As we found out in a recently publicized case, that if you call one of these insurance companies and the prosecutor finds out about it, they may very well do everything possible to find out what it is you said to the person on the other side of that phone. So whatever you say, like if you call us, we're a law firm, and so everything that you say is covered by attorney-client privilege. Makes a big difference.
All right, we got time for one more question. All right. Assyrian Noonie 6. What are the felony ramifications if someone is caught carrying a gun in a gun-free zone like a restaurant in AZ? Not using it in self-defense, just having one. Shows when concealed. This is in Arizona specifically. We have a statute called misconduct involving weapons. That is kind of a tricky statute. It's got all kinds of different subsections. It's like 1,000,000 pages long. Even in fact, that crime that we were talking about earlier about not truthfully informing the officer if you have a gun in your automobile is like subsection, whatever, a
Yeah.
million on page 90 of that misconduct in weapons. But one of those is having a gun in a prohibited place. And so there's different levels of felonies you can be charged with. I believe that one's a class 4 under Arizona law, so it's no joke. It's a very serious crime.
It can be different in different places as well, so it's hard to give advice. Every state's going to be different here. I think it is important to say that if you're an AOR member and you get popped for one of these, it's not a self-defense matter, so it's not covered under the self-defense related part of this. But it is a non-self-defense related matter. So imagine it's a felony, you're an AOR client. We will still help you, but you're going to wind up paying legal fees here. It's 35% off the regular rate. Remember, people forget that all of the different things that the AOR program covers. Most people focus on the self-defense part, right? You check the 3 boxes, it's a self-defense related, or at least you can argue, hey, I tried to act in self-defense. We don't care even if it's a bad shoot. We cover that. You don't have to pay anything. But any other felony, it could be a DUI case, it could be a theft case, it could be a domestic violence case. If it's a felony and it's in any other state and you're an AOR member, you have an option to hire our firm. You get 35% off our regular rates. And so, yeah, you're going to have to pay out of your pocket for that. But if it's connected to a self-defense incident, so you acted in self-defense, you were in a sensitive place, now we cover both of those things with no additional charge.
That's literally what I wanted to hop in and say there, but also another caveat. If you were in a sensitive place when you acted in self-defense, we don't care.
That's
if
right.
it was an illegal weapon, we don't care. If you're a prohibited possessor, we don't care.
If you were drinking, if it's domestic
Drinking,
violence.
high on drugs, domestic violence with a sawed-off shotgun, and you're in a prohibited, sensitive place, we don't care. We can still represent you, and that's what gives our program an edge because we're an actual law firm. But yes, that's an important point of clarification, which is that if it is a non-self-defense related charge, but it's happened during that self-defense incident, no problem. You're covered. You won't pay a dime in legal fees.
I like that we don't have to dance around in exclusion for criminal acts because a lot of people are left scratching their head saying, wait a second, I'm charged with a crime. You've excluded criminal acts, so we don't have to worry about that.
Yeah, so we appreciate your questions, guys. That was great. We got a few minutes left, Mark, and I think that we should talk about this crazy idea that we have of sending a letter to the president and CEO of USCCA regarding some questions that we have.
Yeah, I don't think it's so crazy. I mean, look, this whole thing got started.
How crazy that we're just asking the questions that literally everybody in the 2A community wants to know about recent goings-ons and suspicious crap that we've been exposed to.
I mean, USCCA handled this thing in such a way that brought a huge controversy, right? They left all kinds of questions, and people are...
You're speaking of the Alan Coley case.
The Alan Coley case, yeah. So they left lots of questions open on this Alan Coley case. And we could sit here and speculate endlessly about it or do what I think is the right thing, send a very nice letter over to Tim Schmidt and say, look, here are some questions. You don't have to answer them, but we'd appreciate it if you do. By the way, if you want to ask us some questions about our program, happy to compare, contrast. There are some things that USCC does better. I've said that on many occasions, training. They do coverage for the civil judgment.
Tote bags.
They do some things we don't do. But then let's just have a discussion. I even said, look, if you want to come on, have a discussion. If you want to send attorney Tom Grieve or some other attorney or someone from the insurance company, let's get it out. Let's find out the answers to these questions. That way we won't have to guess about what the contract means or what happened in that case. We'll ask questions and we'll see what happens.
If you guys want us to include your questions in our letter, please comment them below. And if we like them and we want to include them, let's make it a community project to send this letter asking for transparency from USCCA. But I digress. This has been a wonderful live stream, Mark. I love doing these. One of my favorite things to do, and they always feel like they fly by so fast. Feels like we've been here for like 5 or 10 minutes. But
we could definitely extend the time on these. I mean, I'm no nowhere near like tired of answering these. I love answering these questions.
Hell yeah. All right, guys. Well, go and check out attorneysonretainer.us to learn more about our awesome self-defense program. We also have merch now there. So if you go to that website and you can click on the merch button, you can get yourself a cool Attorneys on Retainer shirt. Sign up for the program that best fits what you're looking for. We got family plans. If you got multiple people you want to sign up for, we'd love to represent you and all of your loved ones in this program. Also, go and check out attorneysforfreedom.com. Learn more about our law firm, what we believe in, what we do, what we fight for. This isn't just a fancy name, Attorneys for Freedom, and this isn't just a job and a paycheck to us. We take this stuff very, very seriously, and we're passionate about it. Any last thoughts today, Mark?
No, I'm just excited about doing this stuff. I love answering questions. We got tons of videos coming. We're going to get back to the stuff we love to do, which is
Legal analysis
and educating people about issues related to self-defense. So that's what we do. That's what we're happy to keep doing.
Shout out to IE Independent Events. That's Joey's production company. Thank you, Joey. Thank you to our whole marketing staff. And until next time, my friends, this has been Attorney Andy Marcantel and Attorney Marc J. Victor. Peace.